We have Mark from Dunbar. Go ahead, Mark.
All right, Mark.
You're on the air.
Marco, how are you, buddy?
I'm doing well. Good morning, gentlemen. How are you?
Well, we're all right.
Very good. You talked about the gag order in the Blankenship case.
I bet you want to talk about some gag order in one of your cases, right?
Well, no.
Okay, well, I was wrong then.
No. Similar, though. We have a gag order imposed by the West Virginia Supreme Court where judicial complaints are not public. Lawrence Smith filed a lawsuit. They, took a dump on the First Amendment and said, well, these are secretive. And there's a magistrate in Putnam County, Scott Lawrence, who was banned from hearing domestics from late October to late February. Taxpayers paid about $10,000 to have Marva Crouch come in and hear his domestic docket. And the case is sealed. What are the legal possibilities of filing some sort of a federal suit to force the West Virginia Supreme Court of Appeals to take a look at the First Amendment that every high schooler in the state understands?
Well, apparently you don't understand it, Mark, because no right is absolute. And in matters of the reason that judicial complaints are confidential, at least initially, is because there are some people that folks might consider to be about half nuts who will say anything outrageous about any public official that suits their interest without considering the sometimes harmful effects of that, file frivolous and unfounded complaints, and which can reflect badly on a public official or distract from their ability to do their job while they waste their time dealing with frivolous and sometimes nutty matters. Now, that being said, I'm familiar with the issue with Magistrate Lawrence because I actually had a case down there, meaning in Putnam County, that involved a domestic battery, and it was assigned to Magistrate Lawrence. And I'll qualify this by saying that Scott Lawrence was a friend of mine when he was a state trooper in Putnam County. He married the daughter of one of the former magistrates in Putnam County and is a friend of mine today. That doesn't color my comments or my ability to rationally deal with this. He had an issue, I think, with his wife and a domestic, and it's not a secret, it's a public document, a domestic battery or a domestic, some sort of procedure was initiated. And immediately upon the initiation of that procedure, he reported it to the Supreme Court, and the administrator then said, as an abundance of caution, keeping in mind what happened to Mark Plants, Magistrate Lawrence continued to perform all of his other duties for a period of time until that issue was resolved between he and his wife. Now, that's no secret, and he hasn't made it any secret. And, as is perfectly common in other counties where magistrates become ill or have conflicts or find themselves, for any number of reasons, unable to perform their duties, Marva Crouch, who is a Kanawha County magistrate, retired. We have Jimmy Carruthers' wife, who's a retired magistrate from Putnam County, spent all her time in Mingo County. It is a cost of civilization to replace people who, for any reason, can't perform their duties. Now, I don't know what happened in Scott Lawrence's household. It's not my business as a private citizen. I suspect he feels the sting and opprobrium of embarrassment because it happened and has resolved that issue. And if the court says he's now qualified to serve, he is. The federal court, under the 10th Amendment, has little or no ability to dictate to a state court the rules under which it operates.